lovely law enthusiast humans. Welcome back to my channel. I'm FCA. I do trial coverage and updates on my channel for cases that interest me. Off the top of my head, the Karen Read trial, Corey Richins, Donna Adelson, and P. Diddy are four that I'm going to be covering in the coming couple months. However, there is a lot of court terminology that gets thrown around a lot, and if you're not as big of an enthusiast, or you're new, or just have a general interest, I thought it would be an easier idea, instead of me explaining them in every single video, that I could just refer to this video in any of my trial related things. Now, I am not a legal professional in any way, shape, or form, but I am a legal enthusiast and aficionado, and I think that it's very much in terms of, you don't have to be a professional to have an understanding. Like, you don't have to be a professional baker to know how to bake and know baking things. I will leave all of my research links below for you to double check or look up other stuff for yourself, and also to give any additional details to anything that I'm talking about. So I have a list of terms that come up a lot in the trials and in the coverage that are important to recap sometimes. And I thought I will just list those off. These are the ones that happen a lot. These are not every single term that has ever happened. There's an entire dictionary called Black's Law Dictionary dedicated to legal terminology. However, these are the ones that I hear a lot, or that when I'm talking with people, get confused a lot. So I'm going to go into all of that, and let's get started. Trying to give these kind of in order, and I will put timestamps and etc. below. The first one I'm going to talk about is when lawyers say the court, candor to the court, if it pleases the court. The court is the judge, because the judge, instead of saying if it pleases the judge, some people will say if it pleases your honor, but when people are appeasing the court, the judge represents the whole of the court system. They are the ones who are making legal findings. They are supposed to use case law to make all of their decisions and try to exclude their personal beliefs. That's why they put on the black robe. They are neutral parties who are just making sure that law gets followed. So there's also a reference with the courts to royal courts historically. So that is why the court is also the judge. Judges have a lot of power. You don't have to be charged with a crime to get in trouble in a courtroom. So one of the things that can get you in trouble in the courtroom is if the judge finds you in contempt. Contempt means doing anything that is disrespectful, unlawful, or disobedient in the courtroom. Now, the judge has a lot of leeway on what they can decide is contemptuous in court. They can put anybody for contempt into jail or give them fines. So if you are on the witness stand and you're not answering questions, if you're being purposefully vague, if you're disrespectful, not referring to the judge as your honor, using sarcasm towards the judge, don't disrespect your judge. It's a bad idea. But they can find you in contempt. Another thing that a judge can do specifically to lawyers is sanction them. A sanction is a fine from the personal paycheck of a lawyer as a disciplinary action. Whether they didn't do something correctly in the court system, they did something that is considered to be prejudicial, they outright do something that they were told not to do in previous pretrial things. Again, it's a punishment, so it is not intended to be taken lightly. Just because a little thing happens, most judges are not going to sanction a lawyer, because it is considered a very important disciplinary action that has to get reported to the state bar. And if you are sanctioned a lot or disciplined a lot, you can lose your license over being sanctioned. So it's a really big deal, and it is, again, a punishment that is not to be taken lightly. Very common, powerful thing that a judge can do is acquiesce a request. Acquiesce a request means grant a request. So if a judge is not inclined to acquiesce to a request, they're denying a request. Whatever a lawyer would like to do or have, etc., is being either denied or allowed, is acquiesce to a request. Another thing that a judge can declare is perjury. Perjury is extreme lying on the stand that causes justice to not be served. So perjury is a very extreme offense, and while technically lying on the stand is perjury, there is actually a lesser cause called impeachment that goes along with it. Perjury is extreme. You can go to jail and get fined for that. Impeachment is you've been caught in a lie, bro. Perjury is a very, very rare thing every time somebody lies on the stand. Sometimes even in extreme cases, they don't get charged with perjury because that requires a whole separate trial. And the lawyer has to say, this witness committed perjury on the stand or in an affidavit, and they want them charged or fined because whatever it was misrepresents everything else in the court thing. So it takes a lot to get charged with perjury. It's very, very rare. What's more often likely to happen is impeachment. I apologize for my fan by my laptop. It's right next to me, and for some reason the fan's going into overdrive. My laptop's not even hot or anything. I don't understand why it decided to perk up all of a sudden. Anywho, so then we have motions. Motions are requests by the lawyers. There are pre-trial motions, and there are motions in limine, and then you can have motions that happen in the middle of courtroom. So these are usually filings by the counsel teams. Counsel refers to the lawyers, and they ask for certain things to be excluded, included, or something like that. And those are usually the things that they are asking the judge to acquiesce to. Motions in limine means special things that are going to get objected to. So one of the main things of trial that is very important is to try to keep it moving along, to not waste the jurors' time, because jurors have to be in court for however long court is happening for the trial that they are in, which means they're not at home taking care of housework or laundry. They're not getting grocery shopping done. They're not going to work, and you do not get paid very much as a juror. I think the highest I've ever heard of a state paying people is $30 a day. Other times it's like maybe $10 to $15 a day. And so you are not making the money that you used to, and that can cause a detriment to a juror. So we want everything to move as smoothly and quickly as possible to not be wasting the jurors' time. So before they get brought in, motions in limine literally means limit requests. So in limine means to limit, and the motions are the request, as aforementioned. So the motions in limine are usually shortly before trial, and it's to take care of things ahead of time where, hey, we think that the other side's going to object to this. We want to know what is or isn't allowed ahead of time. And so there's lots of things that go into motions. Literally everything else goes into there, like, hey, we want to ask these questions of this expert. We want this evidence to be brought in. We want this evidence excluded. We want this witness's testimony limited. And the judge gets to go through and pre-approve or disapprove some of those things, and that is motions in limine. That way, when it comes up in court, it's already been decided before an objection happens in court. Now, of course, every objection to every witness isn't going to be brought up. This is more on the whole. Larger issues, like if you have an expert in footwork, you can say, okay, in relation to the trial, here's what they're allowed to say, and here are the questions that are allowed to be asked, or you are absolutely not allowed to elicit this testimony from this person. Stuff like that just gets taken care of ahead of time. Lawyers can also have other special privileges, such as being pro hoc vice. Pro hoc vice is when a lawyer is allowed to practice in a state they are not licensed in. So talking about American law, each state, in order to practice law or be a practicing attorney in a state, you have to get a license from that state. There are times where you can get special permission from a court to practice or act as an attorney in another state. I have never heard of this being used for prosecution. I've only ever heard this being used for defense attorneys, because prosecutors represent the state, so it's unlikely that they would be allowed to represent another state. They usually don't have that kind of time. Defense lawyers have a little bit more leeway, and so if they are granted pro hoc vice, this is you are temporarily allowed to represent a client in another state, or if the courtroom, the venue is getting changed to another state for whatever reason. That happened in the Depp v. Heard trial. Again, even though the lawsuits were taking place in California, they went to another state, so all of those lawyers had to get pro hoc vice into practicing in another law. I believe they were in Maryland. Pro hoc vice is a privilege granted by the court and can be removed by the court. So don't think just because this is not a judge you practice in front of regularly, this is not your home courthouse. If you start acting a fool as a lawyer, your pro hoc vice can be rescinded, taken away, and then you're going to leave your client out in the lurch. Mini type of hearing or interview that can happen is called voir dire. Some people call it voir dire or voir dire, but I pronounce it voir dire. It's a French term, and it basically means a mini interview. Voir dires happen with jurors before they get selected. They get to be asked certain things about to make sure that they are as objective as possible. Usually things along the lines of, have you heard anything about the case? What's your extensive knowledge about this case? Are you related to anybody in this case? Are you friends with anybody in this case? Have you had any personal experiences with this or that? Do you have any overly strong opinions about like police violence or something like that? Whatever is relevant to the case at the time, they want to make sure that their jury is as non-biased as possible, because if a lawyer is able to prove a biased jury, that can come up on appeal and get the whole case dismissed. And again, we don't want that. So we have voir dire. Voir dires can also happen for rebuttal witnesses. So if a witness is coming up to say something against what another person has said, but there's a little bit of different rules for witnesses. Normally witnesses have to be told to both sides, have to be reviewed by both sides, and both sides have a general idea of how and what the witness is going to say. Sometimes you can have surprise witnesses, and these are rebuttal witnesses. They get voir dired to get that information out right then and there, like how they're going to testify, what they're going to say, what they're not allowed to say. And they do that even though it's during trial, not in front of the jury. The jury gets excused for that. Thing that can happen before the official trial begins is a Daubert hearing. A Daubert hearing is specifically for experts to say if they are an expert in what the lawyers are claiming they're an expert in, and if the expert is allowed to make opinions to a jury, because again, they're paying a lot of money for an expert to try to sway a jury one way or another. Usually what happens, if one side is allowed an expert, the other side's going to be allowed an expert. And a lot of times the rebuttal expert, we'll go into that, if they're allowed to make that, because the jury they're the finders of fact. So they get to decide, okay, do I believe this expert or do I believe this expert? Or this lines up more and that doesn't, etc. Those are Daubert hearings. They are where the expert gets put on the witness stand. They get asked questions. The judge asks them questions because, just because somebody is a baker, for instance, they're not going to be allowed, yes, I'm a professional baker, I own a lot of restaurants, or I serve a lot of restaurants, I own my own bakeries, and blah, blah, blah. Okay, are they going to be allowed to say, oh yeah, you could absolutely taste this drug in this pastry? A professional baker, an expert baker, is not going to be allowed to say what adequate prices are, because even though they own businesses, that's not where their expertise is. Stuff like that. That's just an example. It's usually medical doctors arguing medical opinions. And the Daubert hearings also are a part of that motions in limine where, okay, this expert is allowed to be present. They are an expert in what they say they're an expert in, and they're being used correctly. But they cannot be asked about this. They are not allowed to make opinions about this. Referencing in Depp v. Heard, some of the experts for Amber Heard were not allowed to make opinions about Johnny Depp's mental state because they did not interview or sit with him. Example. Of people allowed to say things, there are special privileges and things that are not allowed to be talked about. And so privilege meaning protected from cross-examination. There are privileges. The people who have privileges there is lawyer-client privilege, which means what they talk about with the legal team, it's not just usually one lawyer, there's usually a team of lawyers, and what they say and talk about and strategize about, any conferences that they have between each other, phone calls, emails, etc., those do not have to be talked about. They do not get to be brought up. Attorney-client privilege is only present if no one else is there who is not a legal representative. So if you have like your best friend with you, that's not going to be considered attorney-client privilege because somebody else is listening in. Anything that gets broadcast, shared to the media, your social media is not private when it comes to the court. Anything that you disclose to reporters, anything like that, is not attorney-client privilege. So as soon as you say, my lawyer told me this, my lawyer advised me this, once you share that with other people or share that publicly, that's no longer attorney-client privilege. You've let in, that can sometimes ruin your stuff. Being quiet is your best bet. The next part of privilege is spousal privilege. So husbands and wives are not required or expected to come against each other. So there is a granted spousal privilege. So things that they have discussed and talked about between them with no one else present, they do not have to, that way they cannot get cross-examined or be forced to testify against their partner. This does not apply to children. This does not apply to siblings. This does not apply to parents. It is legally married spouses do not have to testify against each other. We're getting into trial, and first we need a jury. So there is a jury pool. This is just everybody who could possibly be contacted to go into things. So people who are not incarcerated, people who are not in college, foreign exchange students, and people under 18 are some of the most commonly excluded people. They are not allowed to be in the jury pool. Then you get the jury pool, you have them fill out a questionnaire, and then you start narrowing them down. Then you get to a jury panel. A jury panel is the jury pool, only a little smaller than. It's usually a few hundred people, and then the court system gets to sift through to a smaller number to pick their jurors from there after they fill out another form. And then you have your jurors. Jurors are the people, the jury, they are the people who get to interpret the facts and get to make a guilty or not guilty verdict at the end of something. Now, the difference between a regular jury and a grand jury is just to see if an indictment is possible. Only the prosecution goes to a grand jury. So this is a set of outside people who are not supposed to be experts or professionals in anything. They're supposed to be your everyday Janes and Johns who are sitting there, and they get presented with a stack of potential evidence. Again, the defense is not there. The defendant isn't there. It's just the stuff that the state/prosecutors, or sometimes they're called the Commonwealth, they hand that to the jury, that gets explained, and then the jury gets to decide, yeah, we'd make an indictment on that. Or, yeah, we think that you have a convincing enough case that you could win. Because prosecutors, if they don't think there's a chance in heck that they can beat a case, they just will drop it. They'll just dismiss a case because they're not going to spend their time and resources for a case that they're going to lose. So if a grand jury, now everything doesn't require a grand jury. They happen pretty frequently. They're a lot smaller. And it's just, yeah, more than likely or not, you could convince us with this evidence to convict somebody. And if that doesn't happen, then that gives more leeway for a prosecutor to go to the DA's office, the district attorney, and go, listen, we should dismiss this case. We should quit on this case because the grand jury doesn't think that we have anything convincing. A regular jury or a general jury, these are the people, and it's in different states for different cases and different kinds of things. Not every case requires everyone to be unanimous in everything. It sometimes, depending on the case, it needs the majority. Not everybody. And then there are alternatives. Alternatives are at the end of a trial thing, a set of jurors, or their numbers are randomly selected or their letters are randomly selected. And it's like, okay, this person, etc. These will be our sitting jurors. These are the deciding jurors. If for whatever reason you lose jurors, alternatives are there to make sure that the minimum number for that particular trial requirement still stays in there, because there is a thing, which is our next term, juror attrition. Juror attrition is when over the course of a trial, and this is one of the reasons why they want trials sped up and to go smoothly and to not be wasting time. You'll notice that there are a lot of limitations to wasting time. And this is due to juror attrition. Attrition is when people are lost due to day-to-day life circumstances. Not lost as in passed away, but they're no longer able to serve on the jury. In order to get out of that, you usually have to present your case to the judge through one of the other court people. It depends who you talk to and get through that with. Often depends on the state. But you go through and you say, listen, I really cannot take any more financial loss. This trial has been going on for 6 weeks. That's 6 weeks of me not getting paid. And my landlord's threatening to shut me out because I don't have the money for rent. My electricity is getting shut off. My kid is in the hospital. I need to go to the hospital or some other family emergency. Those things happen. Things happen in life where sometimes it's like, listen, you told me this trial was going to be for 1 month, for 4 weeks. We're going into week 7. I can't be here anymore. Or sometimes it's because a juror acted poorly. You are not allowed as a juror to discuss the trial with anybody. You and your bestie can't have trial tea. You can't be telling your family about it. Yes, even because if you're not the person on trial, you do not have spousal privilege. Jurors don't have that. You're not allowed to talk about the case. Sometimes in different states and jurisdictions, you're allowed to have a notebook to take notes during trial, but those notebooks will get collected by the bailiff and stored away until the next trial date comes up. So you're not allowed to go over, you're not allowed to do any research. So if you get found out and get caught discussing or trying to leak information or something like that, then you will be removed from the trial and not being allowed to be a deciding factor. And that often really, really sucks, because that means all that other time that you spent doing that and you don't get to even make the verdict call. So behave if you're a juror. It's an honor. We finally get to have trial. So when a witness is being questioned, there is an order that you have to do. So you have direct examination. This is where the side, either the defense or the prosecution, if they're the ones who are calling the witness, like this is their witness that they wanted into the courtroom, that is direct examination. Direct examination is supposed to be slightly more narrative without leading questions. On direct examination, you are not allowed to ask leading questions. Leading is cross-examination. Cross-examination is the other side gets to question the witness. So the prosecution calls someone up, they have direct examination, then it's the defense's turn That's cross-examination. Then the prosecution or defense, whoever called them in this example, the prosecution gets to come back up and they have redirect. Redirect specifically means it's to follow up and give any questions, to clear anything up, add clarification. So a lot of times in cross-examination, they'll try to keep you really vague. So it's like, oh, so you lied to this person. Well, I mean, yeah, but okay, no buts. Yes, you lied to this person. No more questions. Well, then in redirect, the other lawyer can go back up and said, okay, so you lied. Why did you lie? And then this gives the witness a chance to go, yeah, I was hiding stuff, but we were planning a surprise party. So I wasn't lying to be malicious. I was hiding a surprise party. And they're allowed to add clarification then. And then at the end of a trial, there can be rebuttal witnesses. We already talked about what rebuttal is. These are additional witnesses who are simply there to refute the testimony of other people. Again, that is for impeachment. That usually is not going to be perjury. I've said rebuttal like 6 times. Rebuttal literally means to come back at somebody else, to counter what somebody else has said, to rebut them. So if somebody's like, no, I didn't see so-and-so at this event, and then you have your rebuttal witness who goes, yeah, I actually gave them a photo of me and that person at this event. They were absolutely there. I don't know what such and such was talking about. And they usually don't address people by name. They're usually not allowed to unless explicitly asked. But a rebuttal witness is this person to refute or counter what this person said. Sidebars. Sidebars are the things that motions in limine try to minimize. This is where a question has come up, or the witness has said something questionable, or there has been objection. Can we go to sidebar? This is where the lawyers want to discuss something with the judge privately outside of the ears of the juror. They usually try to make this quick, but the sidebars can go for several minutes because they're making an argument about whether or not a witness, expert, or whoever is allowed to say, do, whatever. So sidebar is when the lawyers go up privately to the judge and they have a little powwow about something that's happened. In order to make sure nobody else can hear, there's usually a white noise sound that fills the room so that jurors and the witness and everyone else who's in the gallery can't hear what's going on. This is a term that gets confused a lot. Hostile witness. When you're treating a witness as hostile, or someone is a hostile witness, that does not mean angry or aggressive. Just because a witness is getting heated, they're clearly ticked off, etc., that does not make them a hostile witness. Hostile means treating them like you didn't call them. So if the defense says, I'm going to call so-and-so to the stand, I would like permission to treat them as a hostile witness. This means you're allowed to ask leading questions if you're granted that if the court acquiesces to that request. They will be allowed to ask leading questions and treat it like cross-examination rather than direct examination, as would be the normal standard. Sometimes this is because the witness changes their story from what they originally told counsel. Sometimes this is because what they said doesn't line up with what anybody else said, and so they're like, hold on, we need to go into that more because this could be a misconstruing of justice if we don't get that down. So a hostile witness just means being allowed to treat the witness for cross-examination even though you're the side that called them to the stand. It has nothing to do with angry or being mad or aggressive or anything like that. We're going to go over a set of objections, like a lot of the common ones, and this is a Rule 18, and we'll get to go over all that stuff. Again, links will be specifically below for all of that stuff. And so objections are when an attorney doesn't like the way or how something is being said, and they have a problem with it. They think it's going to interfere unjustly to their side, that there's going to be bias is happening. So they can say objection leading. That's usually how it goes. The lawyer says objection, and then their grounds why they're objecting. What is the objection about? Leading. So a leading question, as we mentioned before, is where the answer is implied or the desired is implied in there. So saying things like, collecting is something that a hoarder would do, right? Saying something like that. Or saying, when did you plant the fluffy powder in your roommate's purse? This implies that you did something with fluffy powder to your roommate's purse. You're not asking, did you put fluffy powder in your roommate's purse? It's when did you, implying that it already happened. We already know that it's true that it happened. If you are not on cross-examination, you're usually not allowed to ask leading questions. Sometimes lawyers try to get around this by saying, if you remember Elaine Bredehoff, again from the Depp v. Heard trial, what if any? That was ringing in a lot of our ears. Then we have objection hearsay. Now this one's going to be lengthier. Hearsay is anything that was said outside of the courtroom that is trying to be presented as fact. Now there are affidavits, are signed, confirmed statements from people outside of court that are to be treated as truth. Those are hearsay exceptions. But anything that was said outside of court, you can't, even if you're the one who said it, you can't usually say, well, I told them not to go to point. And you can't say that. It was like, I discouraged them from going to point. Does it mean the same thing? Yes, but how you say things in court really matters. Because if you go, well, how did you learn about this? Well, so-and-so told me. Okay, well, that doesn't count. That's not the truth. Just because so-and-so told you doesn't mean that that's accurate. Now, there are exceptions to hearsay of things that happened outside of the courtroom. Oftentimes, even text messages can be considered outside of the courtroom. If you're like, well, then why are they getting read in court? Sometimes it's to rebut or impeach something. And other times it's for present sense impression. Present sense impression means this is what, based on this is the state of mind that this person was in. So if there are text messages or voicemails of somebody going, oh my gosh, I hear him, I'm in the closet, I can't breathe, I'm so scared. Something like that. This clearly shows that this person was terrified at the time or whatever. Excited utterances like you bleep, saying stuff like that. Like clearly this person was mad at this person because they called them this name in all caps or something like that. Those can be exceptions. Those usually get argued about, oftentimes in motions in limine before it gets brought up here. Then you also have public or business records, because those are contemporaneous. Now the word contemporaneous means at the time in order. So at the time of this happened, these things were made. So yeah, the person tried to say that they never owned a hammer, but on the 12th of such and such, they purchased a hammer from Harry's Hardware. And they have the business, here's the receipt from their credit card that says that they made this purchase. Something like that. So business and medical records, stuff like that. What else do I have written down here? Yeah, so there are other exceptions. Again, I will list them below. I will link below to a list of all of them with more explanation. Those are just some of the big ones that get brought up in court. There's assumes facts not in evidence. This kind of goes along with the other things. You're not allowed to say, well, they were absolutely there on this night because I was told that they were there and I saw them coming back from there. It's like, no, you can't assume that is a fact. That's not in evidence. That hasn't been brought up. Well, they were dating. There has been no proof or evidence that they were dating. They're assuming facts not in evidence. So they're trying to bring something as a fact that is not being presented to the jury. You can't just bring outside factors in. Which also goes into calls for narrative. Anytime you have an objection that calls for narrative, that means that there isn't a concise way for this person to answer without them going into a long story that could bring in speculation, assumes facts, and hearsay. So calls for narrative means like, oh, well, how did you meet this person? Why are we going into how they met? We know that they met and they were friends, and the way that they met was through we can't have all that. The next one is outside the scope. Redirect, we mentioned that redirect comes after cross-examination. Redirect is specifically to counter cross-examination. So it is not a new redirect. It's not a round 2 at direct examination. Whatever you want to ask initially, you bring up in first redirect as the team that calls that witness. If something is outside of the scope, that is an objection that refers to, we didn't touch on the subject of ice cream at all in cross-examination. They're coming out of left field. They're trying to get in more testimony without going through the proper procedures. So if it's outside the scope, that means that redirect has gone awry. Then there is objection argumentative. This is an objection to whatever the lawyer is trying to say or is saying to the witness. They are either they're monologuing, they're not asking a question, or they're just doing something to incite anger or a response that doesn't have anything to do with the factual basis or topic. They're just trying to argue with the witness instead of getting information. All of the questions that lawyers are supposed to be asking, they want to create a story for the jurors of what happened. Sometimes it's to create a timeline. They want facts and points to be made. Asked and answered. Again, we don't want to waste people's time. So if the question was already asked and the answer was already given, just because the lawyer doesn't like the answer that was given doesn't mean they get to keep pestering the witness in order to get them to, you can't toddler it. Like, did you do it? Did you do it? Did you do it? Did you do it? I already told you no. You don't get to keep asking the same question over and over. Now, you might get to re-ask a question with additional evidence or for impeachment purposes with something else, but typically once you ask a question, you get an answer. You just have to roll with whatever that is. Speculation. I do this a lot when I'm saying this is my speculation, this is my opinion, it is not fact. This is where either the question or the witness is saying something that they couldn't possibly know. They are speculating or guessing. They're like, well, yeah, I saw them have fluffy powder. They don't know what fluffy powder is versus unfluffy powder. They're not an expert. They're not a drug or whatever expert. They can't, if they didn't make it, didn't have it, they just saw them with a bag with a substance. They don't know that it's fluffy powder or not. And that does get, stuff like that does get argued. And it's one of those things where it really doesn't matter whether or not you know fluffy powder when you see fluffy powder. You're going to get told they're speculating. They didn't have any way of knowing for sure that it was fluffy powder, as an example. Or, well, it was a nice day that day. You weren't in that city that day. You were out of town for a business conference. So you can't possibly know what the weather was like over here when you weren't there. That's speculation. Then there's unintelligible, which can also be called vague or ambiguous. Again, in an effort not to waste time, you have to be as clear and concise as possible. Asking a question that is intentionally wordy to try to misdirect or confuse a witness or confuse a jury is not going to be tolerated. So you can't ask a question like, did you not go to the Knott Woods at not midnight? You would have to say that question as, did you go to the woods at midnight? You can't just throw in things to try to throw things off. I wish that law applied when we went to voting. Speaking of, another objection is relevance. You can't just ask a witness out of nowhere, do you like ice cream? What does this have to do with what they were doing at the tire store at the time of this incident? So you have to be able to prove that your question matters to the point at hand. So if it's not relevant, it's usually going to get thrown out. It has to be related to the case. Again, we're trying to not waste. Sometimes people do get to narrate for certain questions, usually on direct examination. That is the chance for the witness to say their piece a little more expansively, but we still want to keep it to at least some level of down, because oftentimes it's like, listen, we gotta end trial here for whatever reason. So calls for narrative. Then the last one, gallery. This is where the public is allowed to sit in court and watch the proceedings. Anybody can go into court. You don't have to know anybody. You don't have to be related. You don't have to be a journalist. You can walk into your local courthouse during court days, sit there and watch the proceedings. You do have to be respectful of court rules. You're not allowed to interfere. It's not a football game. You can't be cheering in the stands like go prosecution. Can't do that, but you can stand there and observe and watch whatever is going on. It is a right in America. I hope that this is helpful. Thank you so much. That was my layman's term breakdown of some common court terminology. Again, this is nowhere near all of them. I was just trying to say it in an easy and digestible way, so that when I'm talking about stuff, I don't have to keep bringing it up. I will just be linking this video in with all of my future videos. And I hope that you have a good day, everyone. Bye.